We're back. Let's get this going.
What we discussed at the bench regarding State's Exhibit 460. And Stage 460 is the paper copy of Mr. Sledge's email, Mr. Wright's emails.
Right.
On page, on the next to the last, I'm sorry, the last page of Stage 460. And Mr. Schardt is standing next to me, so if he has that, he could pull it up and confirm that I'm getting this part right. There was an issue.
You should get it right.
You want to look at mine?
Well, I don't. No. Continue. I was trying to interrupt. I don't have 460 printed out, so I'm just going to watch out.
Okay.
Okay, go ahead.
Okay. So at the bench, there was an issue. Number 4, does the court have its copy?
I do.
All right. So there was no problem from counsel for the defense that actually voiced any concern about the first full sentence. The concern voiced by Mr. Adams, I think echoed by Mr. Schardt, was the second full sentence. And then they wanted to keep in the third and the fourth sentence. What I told them was that sentence, that number 4 was made in response to the email, and you can tell that from the time and date that it was sent. That was sent in response to the email that was sent to Mr. Wright, and that was dated December 27, 2022 at 5:06 p.m., which was State's 452 Yankee. The email that contains, and it may have been that we did include it twice. So Mr. Wright sent us an email on December 27, 2022 at 8:43 p.m. in response to the email that I sent to him that was subject Sledge Agreement Updated. And in that email, Mr. Wright enumerated 1 through 8 regarding factual acknowledgments. 452 is the email he was responding to that the state has sent. And number 4,
Yeah.
yes. And so to the extent that the counsel for the defendants have all indicated during the break that they would like redacted from any prior iteration, anything that was not included on the final State's 1AS, the final plea agreement, to the extent that number 4 on State's 452 Yankee gives context to that number 4 on State's 460, it would be necessary to be included to show that that was something that the state put on there that it believed to be true, that Mr. Sledge said no, and this was his response through his attorney.
Okay, so I'm confused now on the different iterations that lead up to the final agreement. I understand that one of them is this number 4 that the state was proposing that he say
That he was saying
that he, Sledge, had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. And that is not ultimately what number 4 said. But are you saying that
in response,
are you saying that the defense wants redacted the earlier version of number 4?
yes.
You're
Yes.
okay. I think we're going way down a rabbit hole here. The state seems to me, we don't need anything redacted if it's not being admitted into evidence.
Well, I think it is going to be admitted or at least tendered for admission into evidence. And the reason that it is at issue is because Mr. Sledge said there were things that I absolutely wanted changed that didn't get changed. And this establishes that there were very material things that would have been beneficial to the state that got changed because Mr. Wright and Mr. Sledge requested that they be changed. So I understand why that is relevant. I mean, if these are going to come in, I would certainly think that we need an instruction that they're not to take any of this as factual, because
You love
it's not in
nodding.
fact what he ended up agreeing to.
I agree.
Yes.
Well, can I?
Of course you do.
Yeah.
Some things.
Okay.
Okay. First of all, I agree that Mr. Sledge said that. I also know that Mr. Wright and actually Mr. Sledge acknowledged that some things were changed, some things were not changed.
Mhm.
No one is claiming that nothing was changed. Okay? That's first. But secondly, I want Your Honor to understand, and I sought clarity from the state because I don't work for the state. I was not communicating with Mr. Sledge back then. These initial factual acknowledgments were in no way based on anything Mr. Sledge ever said to the state. The state came up with these factual acknowledgments from a review of the discovery and proposed these. So
Right.
the genesis of these is purely divorced from anything Mr. Sledge stated, okay? It's not, there's nothing that Mr. Sledge said, okay, this is my story, and then the state came up with these factual acknowledgments, and then Mr. Sledge was like, oh, well, you don't have that quite right. This is what the truth is. These were drafted by the state from looking at the discovery.
Okay.
So I would ask if we're gonna let in basically I'm gonna say incorrect information that Mr. Sledge has never agreed to.
You can't cross them
We're
now.
gonna expose the jury to this. I think we need to be a little stronger with the instructions and say, these were drafted by the state and not based on anything Mr. Sledge said. Because I've been doing this for a while.
Right, I get your point. I get your point. And y'all, this is why I had us come a half an hour early, is because 8:30 to 9 was when we were supposed to be figuring out what was coming in, et cetera. But, so Ms. Love, are you not in agreement with redacting things that didn't ultimately come into the final agreement?
Correct, for the reasons that the court earlier alluded to, and also.
All right, and you do realize that some of what might come in like this, if the version of number 4 comes in that is a proposal that YSL Associates were planning to murder Donovan Thomas Jr., that there are concerns with putting that type thing before the jury.
Well, I do want to hear the court. I do want to understand fully the concerns that all of them that exist. And ordinarily, I would simply leave it at that. Yes, I know there are concerns, but in as much as Mr. Schardt has indicated that, well, his version of reality, mine differs slightly, and I would not go so far as to characterize.
I'm not going to give an instruction that says this is not based on anything. Okay.
Well, can I just respond to that though? But if you're not gonna give an instruction, Judge.
I am going to give an instruction
I understand, but
if this even comes in.
this is the problem.
Good, if it
If
comes
this
in.
comes in, I think the jury would want to know, well, where did the starting point come from? And the only way we could bring it to the jury, because I didn't really know until this morning, to be honest, where the starting point was. It's always been a question of mine, how did these even get the first version? Where did it come from? The only way we could really bring that to the jury is to call the drafter of the acknowledgements to the stand, who I assume is Ms. Love, and ask, well, these acknowledgements that you drafted, when did you draft them? Was it based on anything Mr. Sledge said, or was it based on the discovery? Because, and I'm being right here as an officer of the court, Your Honor, I've never been a prosecutor, but I was under the assumption that there was something that Mr. Sledge said that led to the first statements, and then it was like
But
an
there's
editing
no
process. But
proffer.
the first version was not based on anything Mr. Sledge said.
There's no
And
proffer.
that's important, because the jury has to determine, okay, did the state just come up with these? Did Mr. Sledge say certain things and he's backing out of them now? And if we don't make it clear to them that Mr. Sledge was not the genesis of even the first version, I think that question becomes unanswered, and the only way other than an instruction would be to call Ms. Love to the
All
stand.
right, Ms. Love, what's your response to that?
Your Honor, one, again, the idea that this,
All right, I don't need
I'm
like
not
a
trying to go-
full-blown
my response,
rehash of everything. What is your, let me re-ask, what do you propose?
I propose that the court instruct the jury that it is to take as fact no information contained in any iteration of the plea agreement unless that assertion or that factual acknowledgement is in the final version to which Mr. Sledge.
Let me ask you this. Would you be able to get essentially the same information before the jury? And I believe the information you want before the jury is that very material things about the factual acknowledgments were changed at the request of Mr. Sledge and Mr. Wright. Is that essentially the point you want to make?
Blandly, yes. I think that I would rather ask Mr. Wright, did the state ask, because essentially that's what we're doing, because we couldn't sit down with him. Did the state ask your client if he had personal knowledge that the murder of Donovan Thomas was pre-planned by YSL members? Did we ask him that? And did, through you, your client tell us no? Did he say no? He
So
doesn't
what
believe that the shooting was,
he says he did not know.
right.
He thinks it was not planned, but more impromptu, or at least very short or little planning.
Right. So we don't need all of that.
What's his basis for knowing that? I mean, that's part of their problem.
That it was impromptu with little planning?
Uh-huh.
Well, because he was at the house with, if we're talking state's theory, because Mr. Sledge still has not met with us, but if we're talking what we believe is that everybody was talking about it. They were at the house. We have more than one witness who says at Defendant Williams' condo, they met up. And
After
it was
the fact.
Yes, after the fact. And they talked about it. They talked about catching.
Okay, they could have talked about it and it never come out whether it was planned or not.
And based on the conversations, this is what I have gathered, based on the conversations that Mr. Sledge was privy to, his understanding was that it was not pre-planned. And that is the reason when he says what he does, that he says it. So we're not trying to get into what he thinks. We'd be sufficient with, did we ask him that? Did he tell us no? Did we at first have something
Okay,
to
so
that?
I think that's a
effect?
lot safer way to go about it is, did we ask him that and did he say no?
And did he
And leave it at that and not follow up on, here's what he thought instead.
I
Okay,
completely agree. But
okay,
the
well,
part
that's
that
not
I
what you
think
said a
is
minute ago. Okay, so
the part that
go ahead.
the part that I'm concerned about and would like to also put before the jury was, and did we include that question as part of the factual acknowledgments initially? Is that something that he absolutely said no
Okay.
and refused to acknowledge and had insisted that we change?
All right, so it seems like if y'all, the defense wants in portions of number 4, that maybe the sentence at issue could read, he thinks shooting Peanut was not planned, and then redact the remainder of it. Because that shows that he is saying, no, what the state is asserting is not true to my knowledge or belief.
And if the court lets me leave Mr. Wright, I can say, did he tell us? No. Did we
Okay.
ask him, did he have personal knowledge of pre-planned? Did he tell us?
Okay,
No.
but if we're talking about how to redact 460Y if you
Okay, I see.
tender it,
Yeah.
then that would be, I think, a much safer redaction.
So taking out everything except he thinks the shooting was not planned?
No,
or
taking out, leaving in everything except, but more impromptu or at least very shorter little planning. Mr. Schardt.
Well, I just have concerns with the state. Here's the state can have their theories. Mr. Sledge on the stand has said no one talked about the murder. Okay, I mean they talked
Right.
about
At the
Mr.
coffee
Thomas.
shop.
Yeah, at the.
Oh.
They talked about Mr. Thomas had passed, but no one was saying this is what happened. There was no
Right.
discussion. So when you ask someone, if Mr. Steele asked me, hey, was that murder pre-planned? And I say no, then it insinuates, it gives the impression that I know about the murder. I have some information about the murder.
Yeah.
And that's my problem, is just saying that in a vacuum.
Okay. So how about, I mean, the beginning of what he says is really the answer. He said he did not know, and the rest of it is elaboration.
And Judge, the portion that was, let's see. Okay. So based on what Mr. Wright wrote back to me, we included a line that was not initially included in the previous iteration that I think is 452Y.
Okay.
And I think that line is number 8. And we drew the same exact conclusion number 8 of 1AS. Number 8 of the document that did get admitted, which is that defendant personally knows that one or more YSL associates committed the murder on behalf of YSL. So based on the response that we got from Mr. Wright, from Mr. Sledge, that was what we concluded too. And that is why we put in here number 8, which is different, and it may not be in the prior iterations, but as we went back and forth,
Okay. So,
Okay.
I mean,
Judge.
I think that it would be safer in terms of what gets put before the jury if you do this through question and answer with Mr. Wright.
All right.
Would you be?
She hates that.
You let me know whether you're going to insist on tendering, but.
I'm certainly not going to do anything the court says don't do.
Well, I'm not telling anybody how to
And I know.
try your case. That's not my job to do.
Understood. I'm not going to tender it before the lunchtime hour, at which point, if there is an issue that we need to hash out or I need to say.
Okay.
But at this point,
Oh
I
my
am
God.
very much intending to handle this verbally with Mr.
She's gonna go
Wright
past lunch
on
with
the
this
stand.
witness.
I think it's something that I can do clean.
All right. Is that going to be true with regard to also not tendering the different versions, just talking about them?
Right now, yes.
Okay. Yes, sir.
Let me just point out that in regard, and just very briefly, because I don't want to, go back over everything we just discussed, but number 8, that's referenced by.
You're going to have to give me some
in-
number 8 on which.
One-
That's the
1AS,
Donovan
final-
Thomas
the
personal
final
All
knowledge.
iteration.
right. I don't even have that in front of me, but I know it is. I just, there's a lot of evidence in this
It
case.
is-
And I only have 2 screens. So
Is the
give me a
one,
second. to
but I
get
can
it.
orient the court if it helps.
If you'll just give me a second. Okay, that works too. All right. Go ahead.
So 1AS, section 8
Yes.
is the portion that Ms. Love just referred to, where she says that we made changes to the document based on what Mr. Wright said back to us, and so we came up with 8.
Right.
Defendant personally knows. Well, if the court recalls, that is what they asked Mr. Mr. Sledge about when he was on the stand, and he specifically disavowed it. He said, no, that's not accurate. That's not true. And so if we go back to what we talked about earlier this morning at the bench, my simple request was just that, and I think we may have reached there, I kind of got lost a second ago, is that in regards to them sending this iteration and Mr. Wright sending back the response that shows up in number 4, all right, number 4, where he says, he said he did not know. That's the answer to the question. And I think that's where the court ended up, that's the only.
No, where the court ended up, and we talked about that yesterday, was he said he did not know was to the version that the state had proposed that said this was planned beforehand. And the answer was he doesn't know that.
Right, but what we discussed at the bench earlier, and the reason we asked for this portion, for that sentence, the sentences reads, he thinks shooting Peanut was not planned, but more impromptu, or at least very short or little planning, is because that is speculation. That's his opinion. The fact, and you agreed earlier that.
Yes, with regard to whether it was planned or not, that's a separate issue from whether he knows personally that it was done by a member of YSL.
And the personal knowledge is what Love is trying to eject as testimony through the plea agreement. So please don't push back on Adams against this, because Adams is right.
But maybe I'm just not understanding, because I took the court's previous ruling and I thought that they were going to redact. As a matter of fact, they agreed that they were going to redact that particular sentence. That's the only thing that we objected to, because that our position was simply opinion. It was speculation. The fact that it came from Mr. Wright doesn't make it any less speculation as to him trying to explain why his client thinks that. But we asked that be kept out. The court agreed, and we thought that that part was not going to be read to the jury or presented to the jury.
I don't think that part has changed.
It was the email, but that's what we discussed, because we were discussing whether or not these correspondences, including the emails, were going to be presented as evidence. The state said, well, we don't know, we might, we may, and our position was that, well, if this gets presented, we don't want that line should be redacted, just like the other line where they proposed the line about
What he had said.
Right.
Yeah, right. And that's what we're talking about right now. But that's an entirely separate thing from what number 8 ultimately ended up saying. So if Ms. Love is going to somehow get from whatever it was he said, hang on.
Number 4, Ms. Wright's email.
Shout out to Mr. Adams.
If she
He's
thinks
very
she can get from
kind when he speaks.
it was pre-planned, no, he didn't know that. He couldn't say that. To somehow that answer being the basis for putting in, he personally knew somebody did it. I mean, I don't know how she's going to get from one to the other, but obviously that is what they ultimately decided was okay to sign, and y'all can cross-examine Mr. Wright on that.
Your Honor, I'd also point out that how we got where with any of these assertions is not relevant or pertinent to whether or not the defendant, it does not make more or less likely whether the defendants did or did not do anything here. So how we got to any of these, in my opinion, is not relevant.
Well, Ms. Love, you're the one that's putting them all into issue right now.
I'm putting them into issue to impeach what Mr. Sledge said regarding his, regarding whether his.
Okay, so I think that you can ask a few more questions that establish that, yeah, there were very material alterations made from what it started to what it ended up with. And they were made at the request of Mr. Sledge. But frankly, you even have Mr. Wright on the stand saying, but there were other things that the state wouldn't change. So how you deal with that is up to you. But
since I want him to put in front of the jury everything that he recalls as being true, I don't care about the truth getting in front of the jury.
That's going to teeter on attorney-client privilege conversations. So I'm not sure that will fly.
I'm talking about this idea that the state.
Well, the easiest way to do that is, so what was it that you wanted changed that didn't get changed?
Right.
And then why is it that well, that would be speculative, and I just said I wasn't going to tell y'all how to try your case. But Okay. So we are not at this point going to be admitting any of these.
We're not
just going to be
tendering them to-
discussing them with him.
At this point, correct.
All right. Yes, sir, Mr. Steele.
Your Honor, just to follow up on, I believe Mr. Schardt said, would you also go through an analysis of confrontation clause, because the statement now comes from a party opponent and it's used for litigation. It is a clear, to me, bullseye on confrontation clause. So it's really Ms. Love who should be testifying if the state wants to get that in, because that is a confrontation clause, because where it came from, all those questions cannot be cross-examined to Mr. Wright.
Well,
Second, okay.
okay, sorry, I thought you were
No,
finished.
second part, and I apologize, I'll be very brief. Second part is a 403 analysis. You know, it's like saying, Ms. Love
Shout out to
saying
403.
to Mr. Adams, who represents me, did Brian Steele destroy the murder weapon in your presence or in the presence of Mr. Harvey? And then Mr. Adams responds, no. You know, that's really bad for a jury. That is really bad. And that's really what's going on here. So I would ask you to just limit it. The point is what you said. Did the state give ample opportunity to Mr. Sledge through his counsel to make amendments? Answer, yes or no.
Mm-hmm.
Did the state make those changes? Yes or no? And he might say some not. And we may have to go into a portion by portion, but otherwise, I think that it's a wrong witness because of the confrontation clause, and I think it's very prejudicial under 403.
Okay.
Your Honor, we've had the witness on the stand that made the statements, that signed them. We've inquired of him. He's
Yeah, I
made
think that
some.
does take care of the confrontation clause issue. And with regard to 403, I mean, I agree. We've spent the whole morning on this, and let's target the questions to get to the cogent issue, which is, were they able to make material alterations upon request? All right.
Yes, Judge.
Okay. So we ready to get the witness back in and the jury back in? Yes.
And shout out to Savvy Amira. You guys had put so much love for Savvy in the chat. Thank you, thank you, thank you so much. This is so sweet. She says, great content. Please support it. Like, subscribe, share, and join. Shout out to KNW, the Rico chat, and the mods. So thank you so much. This is so, so generous. And look, already we're getting more green hearts. So thank you so much. Thank you so much, chat, also for, you know, being so appreciative when someone else supports the channel, gifts memberships, sends super chats. And what a beautiful argument by Steele to bring up the confrontation clause. Savvy's lime.
It is cold in here.
I'm sorry.
I mean,
Mainly.
I have a heater that he can use if he's cold,
oh no, I mean,
so we don't turn it down.
I'll soldier through it. I'm just,
I can get my heater.
I was just wondering, is it me or?
No, it's cold.